Hello, everybody. This is Denise Davis. As you all know, or most of you know, I created this group because I'm a realtor, but I'm also a realtor who specializes in helping people who are going through the probate process. And each week I receive calls from people who need help, who need some guidance, but who are also experiencing a lot of difficulties with the probate process. And so I created this group because I had wanted to provide some tips and advice, just some guidance to help people when they're facing this type of situation. So today I have with me attorney Nicole Hatcher, who's going to help bring some insight onto estate planning. And but before we get into that, I'm just going to hit on probate just a little bit. So first, I just wanted to make everybody aware what probate is. And you may already know, but just in case you don't know, that probate is the legal process of distributing a deceased person's assets and settling and distributing a deceased person's assets. So those assets are things that belong solely to the person that died. So if they had something that was in their name as well as in somebody else's name, then that most likely will not have to go through probate. If it was, say, a car and it was in their name and in their wife's name, or a house that was in their name and their wife's name, or a child's name, then most likely that will not have to go through probate. But if it was something that was in their name solely, then there's a good chance that those type of things, those assets will have to go through probate. Now, when we're talking about the assets, we're talking about things such as jewelry, antique furniture, vehicles, investments, bank accounts, and possibly even real estate. Now, in North Carolina, real estate does not have to go through probate, but in a lot of cases, it is pulled back into probate. So probate starts with the it starts with the clerk of court. So you would get your papers and you would fill out your papers, take them to the clerk of court. And from there, what the clerk of court is going to do basically is two things. If a will is involved, they're going to validate the will. They're going to make sure that the will is valid. And then they're going to also make sure that the will was executed according to North Carolina laws. So once that part has completed, then the next thing that they're going to do is assign an executor. So if a will was present, and if in that will they listed who they wanted to manage their estate, that person will be assigned as the executor. But if a will wasn't presented, then the court will appoint a person, and that person will be the administrator. Now, these two roles are the same. They carry out the same duties, the same responsibilities. It's just that one was appointed by the will, or by the person that was, died before they died, and the other one is appointed by the court. And then another name that they're both also called is the personal representative. So once the person has been assigned as the executor or as the administrator, their responsibility then is to manage the estate. They're responsible for identifying the deceased person, their loved one's assets. They're responsible for finding the creditors. They're just responsible for managing everything, even down to once everything has settled, then whatever funds are remaining would go to the beneficiary and heirs. And a lot of times it seems like the person that is responsible for managing these estates is the person that's under, I'm not gonna say under attack, but sometimes it seems like the family is coming against this person. And I find that when I get these phone calls, the majority of them are saying that how their siblings now are upset with them, or they're not speaking to them, and just a lot of confusion and drama in the family. So what I wanted to do was not only teach people, or give advice and tips about the probate process, but also make people aware of estate planning. Because even though I know we don't like to think about death, we don't like to talk about death, it is something that's going to happen. And we're going to leave that burden onto our children, our heirs, loved ones, and stuff like that. And a lot of times, I'm sure people don't want a split in the family like that. I would hate it if my two girls separated because they're arguing over or who gets what, or mama said I can have this and things like that, when an estate plan could have settled all of that. So as I said, today I have attorney Nicole Hatcher with me. She is an attorney located in Durham. She serves both North Carolina and Maryland, and she's going to talk today about the importance of an estate planning as well as wills versus trust. And if you have any questions, feel free to ask her. And so I'm going to turn it over to Nicole now. Attorney Hatcher now, sorry.
That's okay. Thank you so much, Ms. Davis. Mm-hmm. So I am going to share my slides. If you can bring those up for me, Ms. Davis.
Okay, 1 second. Let me get out of here. Okay, is this the right one?
Yes, thank you.
Mm-hmm. And let me get out of this stuff. Okay.
Excellent. So it's a pleasure to be here with all of you today. And as Ms. Davis mentioned, estate planning really can help lift the burden off of your family. So the title of my presentation today is Don't Leave Your Family with a Burden. A little bit about me. As Ms. Davis mentioned, I am the managing attorney at Hatcher Legal PLLC. We have offices both here in Durham, North Carolina, as well as in Columbia, Maryland. I am licensed in both states. And I've been practicing law for a little over 21 years, really experienced mostly in business law, business litigation, estate planning, administration, and probate. And we've done some complex litigation, including personal injury litigation. And sometimes those personal injury cases wind up in probate court as well. So it's my pleasure to be here with you. I want to talk to you first and foremost about the 3 biggest excuses or doubts about estate planning. We hear these often. The first one is I'm not old enough, or I have plenty of time to do my estate planning. The second one is it will take too long and I don't have the time or the money to do my estate planning. Or third, I'm not wealthy enough. Well, the reality for all of us, as Ms. Davis mentioned, is that we know death does not have an age. It's coming for all of us. And so it's never really too early to do your estate planning to prepare. The financial and emotional benefits of doing your estate planning will far outweigh any excuse that anyone could make. The reality is that you're either going to pay for your estate planning now, or someone's going to pay for it when you pass away. And finally, estate planning really has nothing to do with how much money you have. It's really about the people you care about. As Ms. Davis mentioned, leaving your family behind in chaos. There are so many examples of families fighting, generations not speaking to one another, and families just truly destroyed. So the goal is really with estate planning to lift that burden and not leave your family in chaos. So the misconceptions continued. I'd love to hear that one excuse that I'm too young, or, I have plenty of time to do my estate planning. Let me tell you a little bit about my story. That's a picture of me in that picture with my husband. This was 2 years before he passed away, holding our little son. He was 48 years old, and 2 years after our baby was born, he was diagnosed asymptomatic with stage 4 cancer. He was way too young to die, but unfortunately he left, and we were very fortunate to have done our estate planning. So this issue is near and dear to my heart because I've lived through the process. So the big picture that I really want everyone to understand is that estate planning isn't about you. It's about the people that you love the most. So what I hope you'll learn from my presentation today, and please do ask questions, is what is an estate plan? Who needs an estate plan? When is the best time to do my estate planning? Why should I do my estate planning now? And how do I do my estate planning? So just generally, all the things that we see in our daily lives is what constitutes your estate. Your bank accounts, checkings, savings, your car, maybe you have a boat or a motorcycle, your brokerage accounts, stocks, bonds, life insurance proceeds, potentially your house and other real estate, your retirement, including an IRA, 401k. You may have some sort of special collection, whether it's antiques, coin collection. My grandmother collected elephants, whatever that might be, is a part of your estate. Intellectual property, and certainly if you own a business. So what are the goals of estate planning? Well, the biggest goal really is to give what you want, the things that you've worked so hard for during your life, to the people that you want, and to ensure that those assets pass exactly to the people you want and not according to the state law, which may distribute them to someone you don't want to have your assets. And certainly making sure that the assets you've worked so hard for stay in your lineage and travel down your family line as opposed to going somewhere else. Certainly avoiding probate court, which Ms. Davis talked about a little bit. That's a big one. That's a big reason to do your estate planning. You want to also maximize your assets and make sure that you're not paying those assets over to creditors, but you're actually giving the assets that you worked so hard for to your loved ones. So maximizing and distributing the assets that you've worked for in your lifetime. Estate planning is also about incapacity. A lot of times we think with estate planning, it's all about our death, but sometimes we're not just, there's some folks in this world, and we know this to be true, are not going to die immediately. There may be a time in your life where you are mentally incapacitated, you are physically incapacitated, you're not able to make either financial decisions or medical decisions for yourself. Planning under your estate allows for attorneys like me to prepare documents in case that becomes your situation. You also may want to fulfill some sort of charitable intention. Maybe there's a college or a university or some charitable organization that's near and dear to your heart. Estate planning allows for you to make contributions to those organizations at the time of death. You want to minimize the taxes that are due at the time of your death. You want to care for and protect the people that you love. You may have minors at home or dependent relatives. You want to make sure that your estate planning doesn't leave those folks in not only chaos, but a financial strain when you are no longer here. You want to pass on your values and your ideals, maybe to your children, to make sure maybe you didn't get a chance to go to college, but you want to make sure your children get a college education. Estate planning allows for you to do that. And then finally, protecting your assets from creditors. There may be a divorce somewhere in the future, whether it be with you or with your children. You don't want to see those assets distributed to someone that you don't want to have your assets. Bankruptcy or any sort of litigation could potentially impose upon those assets. So the question that all of you should be asking yourself right now is, do I have an estate plan? And you might not think you do, but in North Carolina, it's absolutely the case. It's just that North Carolina, the state, has written it for you. And I can tell you that most of you would not like the estate plan that North Carolina has set out for you. So doing your own estate planning allows you to opt out of that plan that the state has designed in case you don't plan. So dying intestate is what that's really called. That means you die without doing your estate planning. You die without a will, you die without a trust. What happens when you die intestate? Meaning you have failed to plan, and so the state law comes into place and determines where your assets get distributed. And that's distributed according to the state law. And that means that your assets could potentially go to people that you do not want to have your assets. Another issue with dying without your estate planning or intestate is that if you have children, at the age of 18, they will receive whatever you have outright without any guidelines. And they could lose those to creditors. They could lose them in a divorce. Your spouse that may inherit from you could also remarry. And they may fail to plan just as you did. And that means that your assets go to a spouse, their new spouse, that you did not know about or intend to have and live, and enjoy your assets. The issue here really is dying intestate without doing your own plan means that a judge will get to decide not only what happens with your assets, but potentially who gets to raise your minor children. A judge will decide who is in control of your children and their money. And probate court is certainly guaranteed. And as Ms. Davis described, that process is long and it's tedious. So the question for you here is, who needs an estate plan? And the answer to that question is, we all do. Your age doesn't matter because we don't know the day or the time or the hour. Your health doesn't matter. We know healthy people die too. Your financial status doesn't matter. In fact, in the state of North Carolina, anyone with assets over $20,000 who does not have a trust will go through probate. And that's going to be the difference that I talk about in a few minutes between a will and a trust. Life insurance doesn't solve the problem. Most people think if they have life insurance, that's the be and the end all, but it's not. And in some cases, it causes more problems because where there's money, there's sure to be fighting. One question you should ask yourself is, are you in that situation where you have minor children? If you do, then you should be asking yourself first and foremost is, what would happen to your children if something happened to you? And most people think, well, my spouse would be able to take care of my child. And that might be the case. The issue is what would happen if you and your spouse, God forbid, were in a car accident and both of you either got injured or died at the same time? What happens to your children? Most people think, oh, my children will just simply go to the nearest relative. Well, that's not always the case. In fact, a court will get to decide who is best fit to guardian your children. And that may mean in the interim, the court will set certain proceedings and hearings and decide what happens to your children while they are determining who is best fit to care for your children. So again, what I want you to know about this is, if you don't have a written plan for your children, the state has one. It's a default plan. And you probably will not like it because the judge will get to decide who gets custody not only of your children, but also who is going to be in custody of the assets and the money you leave behind for your children. So often what we have to realize is that in-laws will fight over our children, and that leaves really a mess for the court to sort out. And how does the court sort this out? I just mentioned there will be what's called a permanent guardianship proceeding. It's rigorous. It takes a long time. It's complex. It's expensive, especially when lawyers have to get involved, and it's lengthy. And the cold, harsh reality, as I mentioned, is if you are a single parent or both you and your spouse deceased at the same time, your children could wind up in child protective services, also known as foster care. And the mere thought of that is just, very scary. So the solution, obviously, if you have minor children, will be doing your estate planning. You get to name and nominate the guardians in a will or a trust document. And we make sure that you nominate backups in case your first choice is not available. So some of you might say, well, I don't have any minor children. My children are older. They're off to college. Well, that doesn't necessarily solve the problem. I like to give this example. When older children go off to college, we often think, well, my daughter or my son is 18 and, if they get hurt while they're away at college, I'm still their mommy. That's still my child. I can just call up to any medical facility and get information on them. Well, that's just not true. Once your child turns 18, under the law, they're considered an adult. And if you don't have what's called a HIPAA authorization, you may not be able to find out what's going on with your child who may be miles away and hurt. So we make sure when we do your estate planning that we take a look at that as well. And that might be true also of dependents. You may have elderly parents or someone at home with special needs. It's important to get your estate planning documents in place so that if something should happen or you should need information, you will not be at any sort of disadvantage. So I have an example here that I like to tell people. I had a young couple that came into my office, and they were going to proceed with getting their estate planning done. And then they decided, they had a young child, lots of things going on. They wanted to hold off. The husband went out of town on a business trip shortly thereafter. He passed away. He died suddenly and tragically, and the estate was not in order. So that young wife was then left trying to figure out how she was going to raise that child by herself, but she couldn't even get access to the money, the funds that she needed just to pay the bills while the state decided how the husband's estate would be administered. That's a horrific example, but those are the types of things that we hear on a daily basis. I often hear also, well, I'm not worried about it because my spouse or my children will inherit everything, and so I just don't need to worry about doing my estate planning. Well, I really like to educate people and let you know that the law is not necessarily as clear as you may think it is. First of all, your spouse or children must outlive you by 120 hours. So God forbid if you were all in an accident or something were to happen to your spouse, if they don't outlive you by 120 hours, then there's an issue, right? If your children don't outlive you by 120 hours, they won't collect as well. Second is it really is a situation if you have no living parents or descendants, then yes, your spouse and children might inherit. But if you have a living spouse, then you have a situation where your parents might inherit along with your spouse or along with your children. And that gets really complicated because, if you've got a scenario where you may have in-laws, your parents may not get along with your husband or wife, or maybe they get along, but certainly complicating it by putting them in business together, by having to own your estate, own real property, and make business and financial decisions or even medical decisions at the time of your death. That could be a real issue and cause problems. And so there's several issues with not planning your estate ahead of time. You leave it up to the state to decide how those assets get distributed. And really what you could be creating is chaos and fighting amongst your family. So I won't go into this, but older children also become an issue if they inherit, because one of the things that we need to remember is that never age, right? If an older child inherits, they've got money coming to them outright. They may not be ready to receive that type of inheritance. But certainly if you have minor children, if your minor children inherit from you and those guardians get a hold of that money, I can tell you so many examples of children not seeing that money by the time they reach the age of 18. So again, and I give an example here of what an average estate that we see looks like. Someone has a house. We know that property values are steadily climbing, but a house of $300,000, cars maybe of $10,000, maybe there's a 401k around $150,000. Life insurance has become much more accessible. People are buying term insurance policies, $500,000, $1 million, $2 million policies for little to no money out of pocket, right, each month. And so we're seeing higher and higher life insurance. What happens if your children, minor children, and or your adult children inherit somewhere between $500,000 and $1 million inherited? I mean, the examples of what could potentially happen are numerous. Again, someone else getting to spend their money, or you having a young adult who is too young to inherit that kind of money outright. And that's one of the problems, really, that I'll talk about in a minute with doing just simply a will, which a lot of people, if they're familiar with doing estate planning, that's all they really know about. So how do we do our estate planning wisely? We really have two options, right? The last will and testament, which most people know about, but option number two is what is called either a revocable living trust or a non-revocable living trust. So I get the question often, what is the difference between doing a will and doing a trust? And when is a will appropriate? Certainly we know if you just do a will, it's probably less expensive than if you go through the trouble of doing a trust. The issue though, is that wills still have to go through probate, right? And so if you have a will and you have assets over $20,000, that will is going to go through probate. That long, tedious process of going to court, filling out paperwork, potentially needing to get an attorney involved, and then having those assets frozen until a judge determines who, what, when, and how those assets get distributed. That's the issue with a will. It's certainly better than nothing, right? It does allow you to nominate guardians for minor children, and it allows you to name beneficiaries for the assets that you own individually. And it allows for you to name who you want to be the executor or personal representative. But again, where a will fails is that it has to go through probate court. They do not provide for incapacity. They're problematic if you decide to move from one state to another. So if you prepare your will here in the state of North Carolina, and then one day you decide to move to Florida, you're going to probably have to spend more money to do a will. That's not the case with a trust, and I'll talk about that in a minute. The other issue with the will, as I mentioned, kids or whoever is going to inherit will get that property outright if they're over the age of 18. And it does not control most property. And as well, it really provides for a very short direction. The court can simply distribute. That's all that they're able to do. So you're not able to protect the money. You're not able to enforce any of those values or ideals about your children going to college or using the money for certain things. A will simply gives the money to the named beneficiary outright. So again, what we talked about was probate court. Well, let me tell you a little bit about what this is. As Ms. Davis mentioned, and I mentioned a little bit, probate court is tedious, it's time consuming, it's expensive. You have to go through a number of steps. Court appoints an executor. You have to publish a notice to creditors, which means you have to tell creditors that there's potentially money for them to collect against. You have to inventory and appraise assets, and you have a fiduciary duty to do that the right way, right? Whoever is the personal representative or executor has a fiduciary duty to handle these assets the right way. And if they don't, there's implications for that. They have to carry out the burden of distributing these assets, right? This is time and energy that family members may not really have. They may have lives, families of their own, jobs, things that, they just don't want the burden of having to distribute your assets. Everything gets reported to a judge. You will need court permission for literally everything. And you may need to hire a lawyer. It's not mandatory, but I can tell you, even for a seasoned attorney, the administration and probate process is not easy. It's expensive, it's time consuming, and the last thing is it's public. So, before we even get into the numbers, when I say that it's public, let's just think about that for a minute. You might leave, let's say $100,000 to your loved one, your child or your husband. When that will goes through probate, it becomes a public document and everyone gets to see what your loved one inherited, which means they could potentially become a target, right? That information is exposed. The reason that we encourage folks to consider doing their estate planning and really looking into trust options, right, which I'll talk about in a minute, is that if you calculate what a probate estate looks like, what it costs to open up and administer an estate, the cost far outweighs what you will pay for an estate planning attorney to draft your estate planning documents and get everything in order early and before you need them. Just as an example, it's $120 to open up an estate and file those initial documents, right? Then there are fees that you will incur. It could be hearings that you go back and forth to. There's notice fees. I talked about the time off from work. All of those things come into play. If you have to hire an attorney, somewhere between $5,000 to $10,000 is not unforeseen for hiring an attorney to help with administration and probate. There's executor fees. Executors can ask for up to 5% of the estate assets. There may be professional fees. You may have to get appraisers, land surveyors for real property. All of that could amount to thousands of dollars. So somewhere between, upwards of $100,000 to administer your estate, depending on how much we have and what we have in that estate, that gets to be really, really expensive. I can tell you estate planning is not that expensive. Probate court, like we mentioned, is very time consuming. A lot of times it takes upwards of a year to really administer and probate an estate. And even very simple estates can take a long time. We already mentioned that a judge gets to decide, so those assets are frozen until the judge gives release of those assets. A better option, as I mentioned, is we try to have people consider a revocable living trust, if not a non-revocable living trust. That's our sort of option 2 that I mentioned. And what is that? Well, what I like to tell people, it's a will on steroids, right? It does all of the things that a will does, but so much more. You get to name beneficiaries for your assets in that trust. A trust that is revocable, it means that it can be revoked, it can be changed or amended at any time. And you are the trustee. You're still well in control of all of your assets during your lifetime. Everything you now own is outside of a trust. But what we do when we set up your revocable living trust is we move those assets into your trust by retitling them. You still maintain the control over your assets. And the benefit, though, is that everything you own in that trust will pass outside of that administration and probate process. Your family will not have to worry about assets being frozen or a delay in time. All they have to worry about is who is the trustee, and to make sure that that trustee is aware that you are the heir and beneficiary. That's it. So the question I often get, and I love this picture, is this man standing outside of his private jet. Aren't trusts only for rich people? The answer to that question is no. So what is a trust? It's really just an agreement, a document that spells out the rules you want followed for the assets that you put in that trust when you pass away. It's almost like a bank account, right? And we all have those. It is a document that allows for you to have full control over your assets in life, as well as full control of what happens to your assets after death. It's the only document that allows for you to do that. A will cannot do that. Now, we've seen wills, and there are wills where attorneys draft all sorts of interesting, colorful things, but wills really do one thing. They distribute your assets at the time of death. They cannot make any sort of other creative options available for your family, right? If you want children to use the funds to go to college, if you want your children to be married, if you want them to follow some sort of religious belief or any other parameters, a will really doesn't allow for you to set those parameters, but a trust does. So let me give you an example. James has $100,000 in a bank account. He wants to leave it to his son, Fred, when he dies. But he wants Fred to be at least 25 years old before he inherits $100,000 and graduate from college. James needs a trust. A will not do that. So a trust solves all of the problems that come with a will. Remember all of those things we mentioned. You won't lose 1 to 7% of your estate to creditors or in probate court, right? Because it's going to pass outside of that court process. You won't need that court process. Your assets will go to your family in weeks, not years, right? And then it's totally private during your lifetime as well as during death. The other benefits of a trust are that it's easily changed. It's usually valid in most states. So if you decide to move from North Carolina to another state, you won't have to worry about spending additional money to prepare another document. Your trust should be honored and respected in any state that you were to move to. It's valid in most every state. They're difficult to attack. It's not a separate tax entity, right? So you don't have to worry about taxes being incurred. It's not terribly difficult to create and set up. And it packs all of your property into one place and makes life and the grieving process much more easy. So when do you consider a non-revocable trust? This is a more intricate question that certainly we would go into at the time of a consultation. But if there are assets that you want to see pass through generations, you don't want houses sold, you don't want land sold, there's ways for us to protect those assets for generations to come. There's ways of us protecting against Medicaid. There's ways of us protecting against your family losing the house because someone needs to go into a nursing home. That's when we're talking about these non-revocable trusts. They're more difficult to revoke, but they're more robust and they protect your assets. So a lot of people ask me the question of, well, I can just go online and prepare my own documents. You could. And we have people who do. The issue with that is if you don't do it right, then what you have is a piece of paper that's not going to be valid. It's not going to be enforceable. And you wind up in the same situation as if no document was created at all, right? They may not comply with state law, which means that a court's not going to honor them. There's no personalized planning with a seasoned attorney. They're usually just documents that are cookie cutter online, and they may or may not do what it is that you really want them to do. That's the issue. And if they're not properly, it won't make a difference. You will still wind up in probate. So there's times in your life where you have to be careful of when you're looking for a bargain. And we say when you need a parachute, that's not the best time for a bargain. When you need a fire extinguisher, you want to make sure that fire extinguisher is going to work. When you need brain surgery, that's not the time to look for a bargain. And I would argue when it's time for you to do your estate planning, that's not the time to look for a bargain either. So I think at this point, most people should be thinking, well, how do I accomplish this? What do I need to do my estate planning properly? Well, there's many ways to make it happen. I think that most people should consider getting started immediately because we don't know the day or the hour. And certainly it's going to be an investment of your time, your money. But at Hatcher Legal, I can say the process is really very streamlined. We are very proactive with our clients. We try to get most estates accomplished within a few weeks to a month. You would have your documents signed, sealed, and in your possession. We charge a flat fee, which I think most lawyers do. And, we're very relationship based. We want to make sure that it's not cookie cutter and that we're doing what's in the best interest in setting up a plan that our clients actually need and that will work for them. So that's what I wanted to share with you all today. My contact information, again, is here for you. And I'm certainly available for any questions.
Okay. I do have a question. So I was speaking with a lady and she was telling me that she had a will. Let me make sure I'm thinking this right now.
Sure.
Okay. Actually, this was a friend of hers that had gotten a will and said that the lawyer told her that was all she needed, that she didn't need anything else. So would he have told her that because maybe she didn't have a lot of assets? Or so, in that case?
Yeah, I think there's a number of reasons why lawyers will simply just do a will, right? Most of those situations, our clients come in, they're like, I don't want anything complicated. I just simply want a will. Just do a simple will. I just want to leave everything to my kids, and lawyers sometimes are not seasoned enough. They're not confident enough. They haven't done enough. They haven't practiced long enough to really say to a client or they just don't want to get into an issue where they might stand to lose that client. They may just say, okay, I'll draft a will for you and that's it. And they don't spend the time to educate clients on really the benefits of doing a trust. As I mentioned earlier, right? If you have over $20,000 in assets, and most people do, if you own a piece of property, if you have a couple of vehicles, if you have, really calculate the assets you have in your house, bank accounts, if you add it up, the average individual has over $20,000. If you have over $20,000 and you do not have a trust in place, you only get a will, that will is still going to go through the administration and probate process. And I think a lot of attorneys fail to explain that to clients. Again, because the client just says, oh, I just want a will, nothing complicated. The lawyer doesn't want to lose that client or doesn't want to spend the time, or that lawyer may just not be comfortable enough to even explain the difference between a will and a trust. We try to do that because most people who want a will don't want their family members having to go to court when they pass away. They're of the mindset that the will is going to avoid all of that. It's going to make the process really easy and my family just gets to inherit. But what really they need to know and have a true understanding is that the will help. It will say where you want your assets to go outright at that point in time. but it does not avoid that year process of having to go back and forth to court to settle an estate, the imposition that's going to be on whoever's doing this to take time off from work while they're scratching, their head trying to figure out what these documents really want and trying to search out and find people and figure out whether they're doing it right. I have right now about 264 pending matters where either folks want to fight because someone didn't do the administration and probate process the right way, or they cannot figure out what to do in order to administer and probate the estate that was left for them to do. So it's a real nightmare.
Right. Yeah, I understand. And what if somebody they have real estate, they have assets, but they don't have creditors? Like maybe they've already paid everything off. Would that person still need to, not have to, but should they still get a trust?
Yeah, that's the person that needs to trust more than anybody. If you have an asset that is paid off, right? Mm-hmm. We may not have a creditor. You may not have a credit card or somebody that's looking. You may be great at paying your bills. But God forbid you were to go out and get into a car accident. The minimum limits on car insurance right now, I think, is $30,060. That means $30,000 per accident, $60,000 per occurrence. I think those are the minimum limits required, right? Mm-hmm. And maybe that's what you have. Maybe your insurance professional didn't talk to you about getting an excess policy or increasing your limits, right? And you just took out the bare minimum, whatever it is that you needed. I can tell you the average accident will climb probably above $30,000, right? Mm-hmm. And God forbid somebody were to get seriously injured or killed. The sky is the limit for what your exposure could be. If you have a piece of real estate that's paid for and that $30,000 gets exhausted, where do you think the lawyers are going to look next? Okay. At that piece of real estate. So if that real estate is in a trust, that's the greatest protection you can have.
Okay, I understand. So if they was in a car accident and the other person, say, gets killed or get injured, and now they're looking at a lawsuit, they could go after the property. So, but if it's in a trust, then they can't touch that. Well,
that's where we get into, and I'm sorry, I got this little cough that won't go away. That's where we get into talking and specializing plans specifically for your circumstance. Excuse me. Okay. So if I have a client that comes to me and they have a piece of property that's paid off, mm-hmm. we may not be looking at a revocable living trust. We may be looking at a non-revocable trust, because we want to take that asset out of their name and truly protect it against creditors.
Mm-hmm. Okay.
Sorry, my little guy gave me his cold, and so I'm fighting it. Oh, God.
Yeah. Well, I truly thank you for coming on and talking to us today, and this will remain in the group. I also plan on putting it on Probate, so as people come into the group, that they will see it. And you provided information that was very helpful, so I hope people will check it out. And I hope you'll come back again and talk to us again in the near future.
It will be my pleasure. Thank you for having me.
Thank you. Okay, well, I'm going to sign us out now, okay?
Thank you.
Mm-hmm.